Welcome, ladies and gentlemen. My name is Shekhinah B, and I'll be moderating an educational, insightful, and exciting presentation that will be moderated also by professionals in the field. We're going to call this Demystifying Royalties and Digital Pay, sponsored by the Women's Coalition for Empowerment, dedicated to educating, uniting, and empowering women. I present to you Jeff Bryce, rights consultant, rights royalties, digital pay. He's a musician extraordinaire, Grammy nominated. No, I'm joking. And all of the above. Ladies and gentlemen, Jeff Bryce. Hey.
Hey, how you doing?
And along with us is an amazing artist, Temika Moore, Grammy nominated, Oscar nominated, Emmy nominated.
Tony.
She actually has the award for the best teeth on this side of Earth. I'm still trying to get my dentist to copy what's going on here. All right, all the fun and shenanigans. So we're going to open it up with Jeff providing us with much needed information, because it's a conversation that artists, creators, creatives don't typically have. How to secure the digital bag in terms of royalties. We create a lot and we kind of leave it right there and we don't move forward with how do we establish a consistent flow of sustainable income that's documentable and ongoing. So Jeff, take it away.
I'm going to go ahead and share my screen here and pop up my presentation here. Okay, can you see my screen?
I sure can.
Okay, well, thank you for having me today. My name is Jeff Bryce, and I'm a business consultant with a specialization in music rights management and administration. I have an extensive background in the music business. As you mentioned, I've been a teacher and a performer. I play saxophone, at least up until the age of COVID. And aside from that, I worked at SoundExchange for 16 years, which is part of the scope of this presentation. I started there as an account manager, and through the years, I worked my way up to be director of multiple departments. So I learned quite a bit about how SoundExchange works and the royalty streams. And since I left SoundExchange, I have worked as an independent rights management consultant, helping songwriters and recording artists, record labels, and record producers collect their royalties from different sources.
Awesome.
Yep. So in this session, we're going to cover sound recording rights and how you get paid for those. And we're going to talk about statutory licensing, which is important for how you get paid. We're going to talk about the distinction between featured and non-featured artists, which is also important when it comes to sound recording royalties. We're going to talk about the role of producers and engineers and mixers and how they get paid royalties. And then we're going to talk about direct licensing and how that impacts your royalties. And then we're going to talk about some things to do, so some activities or sort of things for you to look at. All right, so the scope of this presentation is specifically for sound recordings, but I thought it was worth mentioning songwriting because it always comes up. It's important to understand that when it comes to songwriting and song rights, it's the publishers of songs that collect royalties for the use, underlined, of the composition, and then the publishers pay the songwriters per their contracts. So examples of uses of the underlying song or the composition is a recording of the song. So if somebody records your song, then you can get paid royalties for that. If somebody takes your song and puts it with a movie or a TV show or a video or something on YouTube, even if it's not you performing it, that's called a synchronization, and you can get paid for that. That's an important thing to remember. Synchronization, also known as a sync license. And then there's the public performance of the song in venues and in media. If somebody plays your song in a concert venue, you can get paid for that, even if you're not the one playing it. If a radio station plays your song or a webcaster plays your song, you can get paid for that as the songwriter or publisher. So that's the songwriting, okay? So that's just songwriting in a nutshell. But sound recordings have separate rights, and that's really important to understand. That the sound recording is distinctly exploitable from the underlying composition. That's, again, an important distinction. The sound recording is a separate product from the song that you wrote. Even if you're the songwriter and the performer and the record label and the publisher, there's a different right associated with each piece. So it's important to remember that all those components can be monetized. So just remember that the sound recording is separate from the underlying composition. And sound recordings have different rights holders. The rights owner is usually a record label, and they're the ones that own the rights to the recordings themselves. Then the artist performers have rights as well. And then in addition to the artist performers, you also have the record producers, engineers, and mixers. All of them have a stake in the rights to the use of the sound recording. Whether or not they wrote the song, or if they're covering the song, or if they own the rights to the song, the sound recording is separate and have separate stakeholders and owners to the rights. It's also important to remember that it's the rights owner that has the right to license the content. It's record labels, usually, that have the right to authorize the use of their recordings. And the rights vary in different types of media. So for instance, downloads, reproductions, and as I mentioned, synchronization and interactive streams all require permission from the owner of the rights. So a download, that's considered a reproduction. If somebody makes copies of CDs, that's a reproduction. If somebody takes the sound recording and puts it to a movie or a TV show or YouTube or something like that, that also requires licensing, and that has to come directly from the rights owner. And then the interactive streams require permission as well. So when you have premium Pandora, when you can select a song and you play the song and fast forward and rewind, that's considered interactive, and that has to be licensed directly from the owner of the rights. On the other hand, non-interactive streams are permitted under what's called the statutory license, and we're going to dig into that into the next slide. But a non-interactive stream is like the type of stream when you're listening to a Pandora, but it's the free version of Pandora, where you can pick a channel or you can pick a style, but you don't pick the song, you can't fast forward and rewind. That's considered non-interactive. Now, yes, some webcasters allow you to skip a certain number of songs per hour or something like that. They decided, when I say they, the transmitters say that's not interactive. Nobody's ever tested that in court, but it's basically been let go. They said, okay, fine, 5 clicks. Nobody's ever sued anybody about that. So that's not really considered interactive. But the non-interactive streams are permitted under a statutory license. And then radio play, which is your typical terrestrial radio that you hear in your car, that's free promotional value. They don't pay for the sound recording on the radio. They do pay for the underlying composition on the radio, but they don't pay for the underlying sound recording. And that is a whole separate conversation right there. Let's go ahead and dig into the statutory license. So the statutory license was created originally by the Digital Performance Rights Act of 1995. And that established the initial performance right that says, you know what, we didn't have a performance right before in radio for the use of the sound recording, but this whole new digital technology thing in 1995 and satellite radio, this whole new thing, that's really high fidelity reproductions and transmissions of recordings. So we really think there should be a performance right for the use of the sound recording there. And that's where that comes from. And that covers satellite radio and also covers cable and satellite services like Muzak and Music Choice. Now, this was later enhanced by the Digital Millennium Copyright Act of 1998. I'm sure you've heard the term DMCA. You've heard about takedown notices on YouTube. DMCA is a very, very broad law, but it also expanded the performance right to cover webcasters, which was also a new technology at the time. So the main takeaway there is that webcasters are also included and required to pay the performance right for the use of the sound recording in addition to the use of the underlying composition. And then these rights were recently expanded by the Music Modernization Act of 2018. And the details are still being implemented, but it does have an impact on specific entitlements, specifically for producers. It closes a loophole for paying for pre-1972 recordings, and also creates a provision for a new mechanical licensing company, which is just getting started this year. But the important thing to take away from all of this, whether you remember any of this information or not, is that there's a so-called blanket license. The statutory license is also known as a blanket license, which provides for non-interactive digital transmitters not needing to get permission to stream the recording. So unlike interactive streams and downloads and reproductions, non-interactive transmitters don't have to get permission from the sound recording copyright owner. They simply operate under the statutory license, which is created by law, and they can play whatever they want as long as they perform it or transmit it under the provisions of the statutory license. And it's very detailed. We won't cover that here, but it is important to remember that those non-interactive digital transmitters can transmit whenever they want to. Like, I mean, there's certain guidelines, but they can transmit recordings without getting permission. They're required to pay licensing fees, but they don't have to get permission from every individual rights owner to do that. And that's really the purpose of the blanket license, is because otherwise a transmitter would have to get permission for every single recording from every single rights owner and negotiate the terms for every single one. That's extremely inefficient traditionally. So the blanket license was created in the public interest to say, you know what, you put the music out there, obviously you wanted to get played. They're going to make it easier on the transmitters to transmit the music. The trade-off is that, you know, you can't say no, but they're going to have to pay you. So that was kind of the trade-off there. As part of the statutory license, the transmitters are obligated to pay licensing fees to SoundExchange, which then converts the fees into royalties. So SoundExchange is the sole agent, the only agent designated by the Copyright Office to collect licensing fees under the statutory license. That means SiriusXM pays licensing fees to SoundExchange for the use of the recording. Pandora pays licensing fees to SoundExchange. Any kind of like transmitter that transmits online, non-interactive, at some point is going to go through SoundExchange. All right. Now the statutory rights are very specific. For every transmission under the statutory license, the record label gets half. So for every stream, every transmission, the record label is going to get half of that. And then the quote featured artist is going to get 45%, and the non-featured artists will get 5%. And you might look at that and say, hey, well, why? That's not fair. How come the record label gets more? The basic idea is that for every stream, it gets split into half. That the rights owner gets half and the artist gets half. But it was understood that there can be a distinction between who is featured and who is not featured, but playing on the record. So it was decided, let's go ahead and carve out a little piece for the non-featured artists. So we'll set aside 5%. It doesn't matter if you have 100 non-featured artists on your record or no non-featured artists. Even if you did 100% of everything, 5% will always be deducted to pay the non-featured artists. That's simply a statutory deduction to simplify it. The main purpose is to simplify it. There are some other allocations. If you own the rights to the recordings, there's this concept of the ephemeral sound recording that every time a transmitter makes a transmission, they're probably going to have to make a copy of the recording. Typically, a copy of the recording is not permitted without getting permission. So they baked it into the statute saying, well, we understand that you're going to have to make copies sometimes to make these transmissions. So we're going to build that into the statute, and we're going to set aside some money for the copyright owner for that. Because we don't want to say it's okay to transmit, but it's not okay to make copies to facilitate the transmission. So they built that into the statute. Then there's business establishment services, and this covers services or businesses like, say, Starbucks or some other place that pumps in satellite radio, where their business is not to play music, but music is part of what they're doing. It's in their background. They're using the music. In that case, business establishment services also pay licensing fees, but the main distinction is that the transmissions themselves are not eligible for royalties. They simply pay a licensing fee to make those local reproductions. That's really what the point of that is. And then there are also small deductions taken out of the royalty pool for SoundExchange for administrative costs. Now, SoundExchange collects the money first, and they're a nonprofit organization. Whatever it costs for SoundExchange to pay the money out, that's what it costs. Now, SoundExchange's administrative cost is usually like less than 5%, which is ridiculously low, either by nonprofit organization standards or by performance rights organization standards. A good nonprofit is going to have an admin fee of less than 30%. A good performance rights organization, which is typically a type of nonprofit, is going to be less than 20, maybe 15%. SoundExchange is the lowest in the world. So it's less than 5%, but SoundExchange gets paid first. And then they allocate all these all these different percentages, and then they pay for the stream. So that's where this split comes into play. So we have this featured artist versus non-featured artist distinction. And as I said, the featured artist gets 45%, and the non-featured artist receives 5%. But what does that mean? What is a featured artist? Well, the best definition we have is the featured artist is the performer that is displayed most prominently in name and or an image on the phono record. The phono record meaning the physical embodiment of the song or the recording. It could be the CD, it could be a vinyl album, or it could be just like, the MP3 or the file that gets circulated. That's considered a phono record, all right? So in this case, we've got Drake, right? And this is, again, in name and in image on the phono record. So this is a lot of evidence that Drake is the featured artist, right? It's not proof, but it's evidence. This is a lot of evidence that Drake is the featured artist, which means that he would get 100% of the artist's portion, the featured artist portion. So he gets 100% of 45 based on this information. But then you have this one track from this album, and it features Jay-Z. Well, it says featuring Jay-Z. Well, what is it? It says Drake. It has Drake on the cover. It's a Drake album, but it features Jay-Z. Well, what is it? Does that mean Jay-Z doesn't get featured artist royalties? It says he's featured. But does Jay-Z get 100%? I don't know. And neither does SoundExchange. And traditionally what would happen is that SoundExchange would simply split the money based on what's reported. So if Sirius says, hey, we played this song and it's Drake and Jay-Z, they said, I think we're going to split the money in half. We'll just split the feature artist 50-50. If it gets reported as Drake only, we'll pay Drake 100%. But the challenge then becomes that the same recording gets reported 2 different ways and can get paid 2 different ways. We could ask the artist and say, hey, what does your contract say? But at that point, you're paying a $400 an hour attorney to spend hours thumbing through a contract, and this different variation of the recording might be worth a couple $1,000s. Do you really want to pay your attorney hundreds of dollars? Sometimes it's it's not worth as much as you're going to pay your attorney. So they will simply split the money equally, and then if it's wrong, you just let them know and they'll fix it. But when it comes to putting your content out in the world, it's really important to understand what it signifies when you're putting featuring or what it means, because that could mean that, well, this person might be due royalties when you just wanted to just give them credit. So that's something that's important to consider when you're making your arrangements for getting paid for these things, because SoundExchange doesn't know anything other than what's claimed and what's reported. They don't know. You have to tell them, right? Now I've got this Beyonce recording. Looks pretty clear. Beyonce is the featured artist, right? Sasha Fierce, 100%. Really not a whole lot of question about that. She's on the cover. It has her name on it. It's pretty clear. And if you look at the liner notes, if you scan through, you can see there's a lot of different roles. And you have people that played instruments. They played the drums. They played guitar. Other people actually played on this recording, but are they featured? Probably not. There's not a lot of evidence that anyone other than Beyonce is featured, which means that someone else, like say Jen's Gad here, and Science on If I Were a Boy, might be able to receive royalties as a non-featured artist, but probably isn't considered featured. Even if you had an important part, like a main melody or a really great solo, probably not going to be considered featured. Now I've got Destiny's Child. It's their first album. Well, who's the featured artist here? All we know is that it's Destiny's Child. Do we know that it's a 4-way split and everyone gets 25%? How do we know it's not Beyonce getting 50% and everyone else splitting the other half 3 ways? We don't know. All we know is that the artist is Destiny's Child and it may have 4 members in it. We have no idea how those royalties are split. No idea. All we know is that Destiny's Child is the featured artist. But then we have Destiny's Child, the featured artist again. But you can tell that the lineup has changed. The membership has changed. The number of members has changed. But we don't know. Does we know it's a 3-way split? Maybe it's still 50% Beyonce and the others will split the other half. We don't know that. So that's something you have to tell SoundExchange, and it's something you really have to figure out. Because if you don't agree or if you dispute it, SoundExchange will hold your money indefinitely and nobody gets paid until you figured it out. And if you call SoundExchange to ask them and say, what's the status of my dispute? They're going to say, I don't know. You tell me. What is the status of your dispute? Because all we know is what you tell us. If you're in disagreement, we're not paying anybody. So that's an important consideration. That in both instances, Destiny's Child is still the featured artist. And when SiriusXM, Pandora, iHeartRadio, when they report this to SoundExchange, they're just saying, this is Destiny's Child as the artist and the album is Destiny Fulfilled. Or the artist is Destiny's Child and the album is Destiny's Child. That's what's getting reported to SoundExchange. So you have to be prepared to report that to SoundExchange to tell them how to pay you. Here's another interesting example, Sade. Her first album, 1984, one of my favorites, Diamond Life. It has her name on it, Sade, and it pictures Sade. But if you look at the liner notes, which I don't have here, but it actually says Sade R in the liner notes. So it features her on the cover, but is Sade the name of just a person, or is it the name of a band that's named after a person? Because if you say Sade R, well, that's a little scrap of evidence that maybe the drummer, one of 4 members, should be a featured member of a band, right? But again, we have Sade's name on the cover. It has her on the picture, her face. That's a lot of evidence, but there is an argument that somebody who played in the band of Sade could actually be due royalties. And that doesn't even get into, like, her band, was it Fatback, that plays separately from Sade, which could be the exact same members, just everybody without Sade. It doesn't even get into that. Now, Fleetwood Mac, a band that's been around for decades, has had 40 different lineups, and one of their biggest lineups was for this album that came out in 1977. It had, I believe, 6 members, but it only features Mick Fleetwood and Stevie Nicks. It doesn't even have John McVie, who was also part of the namesake of the band, on the cover. Does that mean Mick Fleetwood and Stevie Nicks split the money 50-50? Well, no. We just know that the featured artist is Fleetwood Mac and the album is Rumors. if either one of them want to say, hey, I'm the featured artist, or I'm 50%, there would be some evidence for that. But then you'd be saying, well, John McVie, who's also in the name of the band, doesn't get paid at all. So again, SoundExchange doesn't know. You can make these arguments all you want, but you have to discuss it among yourselves and figure it out. And your contract may not address it at all, especially for these bands that have been around for a long time. Maroon 5, another example, is that Adam Levine, the main guy, is at 5 different people. There's not a lot of information on the cover. All we know is that the featured artist is Maroon 5, no matter who did what on the record. But producers, engineers, and mixers also have an entitlement. Now, traditionally, they're not considered statutory royalty recipients. Those initial copyright acts that I mentioned, Digital Performance Right Act, DMCA, they don't mention producers, engineers, and mixers. So they're not considered what's called statutory, in quotes, royalty recipients because they're not mentioned by statute. But they are considered customary royalty recipients because they always have received royalties per their contracts. What would happen traditionally is that the record label would collect all of the money, all the sound recording money, and then they would allocate the money based on the contracts, which would include paying the record producers. And the record producers would get paid out of the artist money. So whatever the artist would collect from their record contract, a tiny piece of that, 5, 6, 7%, would get paid to the record producer, and the record label would handle that. They would handle all of the accounting. The artist never had to worry about that because the record label handled it. So the label would collect all the money and then allocate all the money, and the producer earnings would be deducted from the artist earnings. But SoundExchange has always paid the artist directly and never paid the label the artist money. Now, historically, the record label always collected all of the money first and then would pay the artist based on their contract, but the record label would always get first crack at it. But when SoundExchange came onto the scene, they said, you know, we're going to pay the artist directly. We don't care whether or not this is recouped. We're going to pay the artist directly. This was a big win for the artists. This is great, man. The artists are getting money they never saw before. They're getting paid their sound recording money. But the issue is that now the record label is cut out of the administrative process. They're only collecting the record label money. So if the record label was supposed to deduct from the artist money to pay the producer, well, they can't do that anymore because they don't get the artist money. But the money is still due to the producer, which means that the artist was still obligated to pay the producer out of their own pockets. Meaning that when the artist collects money from SoundExchange, they would have to turn around and write a check to their producer per their contract, but they had never done that before because the record label had always handled it. But irrespective of that administrative issue, the producer is still due royalties per the artist contract. So if there's any producers or engineers or mixers out there, you can still get paid. You just have to pay very close attention to your rights. In order for you to get paid, you have to submit a letter of direction, or simply LOD, which provides instructions for paying royalties to someone other than the artist. So your letter of direction, which is probably already part of your contract with the artist and the record label, is something that you would complete and send to SoundExchange. Now, SoundExchange has its own form, so if you have a letter of direction with your record label, okay, great, but you have to fill out a specific letter of direction for SoundExchange, have the artist signed off on it, and then what will happen is that SoundExchange will process that letter of direction and then start deducting the artist money and start paying it to the producer per their contract. So SoundExchange will pay the producer directly if you get a letter of direction from the artist. Now, the artist can submit it, or the producer can submit it, but it still has to be signed off on it. But whether or not SoundExchange receives a letter of direction, the producer is still due royalties. The producer, engineer, or mixer is still due royalties, right? It doesn't matter if you submit a letter of direction or not. It doesn't matter if SoundExchange knows it or not, or has paid it or not. The producer is still entitled to this royalty, right? This is an area of much confusion in this space. It's been an area of confusion for many years. It's still happening out there. The Music Modernization Act tried to correct it by mentioning producers by name, but it still didn't automatically make it possible for them to collect money. They still have to get permission from the artist to do that. But either way, copyright law or not, they still have a contract, and the artist is still obligated to pay the producer one way or the other. Okay, so we've talked about statutory licensing. Direct licensing is the flip side of that. The statutory license, again, is a blanket license and says you can transmit these recordings without getting permission from the rights owner. But the statutory license was not meant to prevent the parties from transacting directly. Copyright owners and rights owners and transmitters were always able to transact directly. They could always make a deal privately. and they could exclude SoundExchange if they want. Again, the whole purpose of the statutory license was to improve on the efficiency because it was so inefficient. But if you found it efficient or just more effective to go directly, you are always welcome to do that. So why would you direct license? Well, it's a private agreement between parties, so you can actually make your own deals if you want. One of the advantages is that the broadcaster can get a lower royalty rate, meaning that we're not going to rely on the statutory rate. We're just going to work on a private deal between you and I. If you want to give it to me free of charge, great. That's perfectly fine. And that removes the middleman, so that removes SoundExchange and their meager 5% or whatever admin rate. The advantage to the record label is that they can collect all of the money like a traditional agreement. Now, that's important, and that's why I highlighted it, is that if the money comes through SoundExchange, the artist gets paid no matter what. But if the record label licenses directly, even at a lower rate, they collect 100% of the money, and they can decide to do with it what they want, including recoup. Now, when I say do with what they want, okay, well, it still has to be per their contract, but again, they're collecting all of the money, and they can do their recoupment and do whatever they need to. So that may be an advantage to the record label, is that, well, why would they license to Pandora at a lower rate? Well, they can keep more of the money, and they also cut out the so-called middleman. So that might be an advantage. Whether or not that's financially advantageous, well, that's up to you to make that decision. But it's a free market. That's why you're allowed to direct license. That's where that comes into play. Okay. But SoundExchange also does administer direct licenses. So while they're still doing the statutory licenses, it's still more cost effective to say, look, we have these special terms. They're not the statutory license terms, but it's still more cost effective to have SoundExchange handle it. So SoundExchange still is in the mix when it comes to direct licensing. And what will happen is that the record labels will sometimes pay SoundExchange to pay the artist. So even though the record label can keep 100% of the money, they might say, but we're going to have you pay them directly anyway. We're not going to recoup. So even though the record labels still can direct license and collect 100% of the money, most of the record labels, from my experience, are saying, but we want you to pay the artist. We're not going to keep all that money. We want you to pay the artist. So they'll actually pay SoundExchange extra money and give SoundExchange the money and say, please pay the recording artist for us. It's much cheaper for you to do that for us, rather than us having to run through the contract. So it's not all a sinister, dastardly deed. It does work out for the artist in both cases, but it is a bit tricky because you can't necessarily tell if your record label has licensed directly or not. So it's often unclear if the transmissions are covered under a statutory license. And it's really difficult to validate if the content has been licensed properly. So what will happen is that an artist might receive money from SoundExchange every few months, and all of a sudden their money drops off. Well, why is that? Is it because they're not getting played anymore? Well, that could be it. Or it could be that the record label licensed the content directly, and it's changed how they're getting paid. It could be they're getting paid less. It could be they're not getting paid the same way. They're getting paid, through the label instead. But I've seen that happen where somebody is getting paid and then suddenly they're not. And it's almost certainly as a result of the direct licensing change. And it's very hard to get transparency into that. That's one of the challenges of dealing with that in this space, I'm here to tell you. All right, so things to do and see if you want to get paid. Well, the first thing to do is register online with SoundExchange. You register as a recording artist, a label, or both. And to do that, you provide your payment information. What's your payment information? Well, you need a name and address. You're going to want to use your actual name and not your business name, and use your social security number, especially if you're a single member LLC. You might have a federal employer identification number, but as a single member LLC, you're going to want to submit your social security number and put your personal name, otherwise SoundExchange won't accept it. Recommended you provide your direct deposit information so you can get paid as frequently as possible. And then you can decide if you want to become a member of SoundExchange. It's important to note that membership is not required for you to register and get paid, but it does confer certain membership benefits, which could include collecting royalties overseas. And it shouldn't cost you anything extra, but that's something for you to consider if you want to become a member or not. If you register with SoundExchange, you should submit a repertoire chart. It might not be required, but you should because it's helpful. And if you have ISRCs, which is International Standard Recording Code, you should definitely get that and provide that to them. And if you're part of a band, you're also going to want to provide the lineup information, meaning if you're one of 4 members of Destiny's Child, well, I get 25%, and it's really, really cool if you mention the other 3. That way you can help each other out. So bands that get along well, that's a good thing for you to do. Pause for a moment to take a look at that. Okay. Also things, so when you register, it'll set up a SoundExchange Direct account for you. It displays your account information and payment history. It shows you what your registered name is. Now, I've redacted the names for some clients that I have. You can see it shows you the registered name, the status of the account, when you last got paid. Tells you what's registered with them, your rights owner catalog, your artist catalog. You can submit new tracks. You can look at tracks that are getting paid. Everything you've uploaded. You can look up ISRCs. You can download your information. Now, if you've played on other people's records and you're not a featured artist, you can still get paid, but you have to go to a separate fund. And I mentioned that 5%. Now, you don't go to SoundExchange as a non-featured artist and say, give me 5%. I'm a non-featured artist on Drake's album. You actually have to go to this fund, and SoundExchange pays that 5% to this fund, and then you have to go to the funds to make your claim. And the fund is administered by the AFM SAG-AFTRA Fund. And you have to go to their website to claim royalties. This is their website. You can see that you do have royalties for you, sound recording, audio visual, symphonic royalties, but you have to pick which applies to you. And then you look for all of the songs that are eligible and claim which ones apply to you. And a lot of this information does come from SoundExchange. When SoundExchange collects the information, the sound recording information and the money, and then they make their allocation to the unions, they also, when they make their payment, they provide the data. So that's what you're seeing here is the data that ultimately came from the digital transmitters. All right, that was a quick blast-through overview of sound recording and copyrights. Again, if you want to get in touch with me, here's my information. I'll post that and make it available to you. MyRoyaltyGuide.com is my website. One way you can reach out to me and get in touch with me there, and I'll put my information in the chat. Be happy to take any questions afterwards or see in chat. And we can talk afterwards and take it offline. I'd be happy to be of service to you and be happy to have that conversation. Otherwise, thank you for listening, and I'm gonna turn it back over. Thank you.
Thank you, Jeff. That was extremely comprehensive, extremely helpful, very detailed, and I did put a link in the conversation chat box of SoundExchange. I'm so excited that you actually demystified a lot of that information, because a lot of times artists will just record, create, develop, and then all of a sudden it's like, nobody's paying me. And now we're trying to demystify that process. Mm-hmm. And I want to thank you so much. And please don't go anywhere, because we might have some questions toward the end. Everyone that's watching or listening, please submit your questions either in the chat box, or you can submit your questions to me in a DM and I'll say them out loud for you guys. Thank you so much. And now I'd like to introduce Temika Moore. Artist, businesswoman, arts advocate, vocalist extraordinaire, Temika Moore.
Oh, that's an awesome intro. That's awesome. I just want to say, Jeff, you're awesome. The way you break it down, and of course, I always say, there's left brain and right brain, and I said he hit the perfect sweet spot between left brain and right brain, because everything you said that was technical, I thought of it in layman's terms. It's like, yes, I got it. Yep, I see it. And I'm like, that is wonderful. So hopefully all of the artists and aspiring music business professionals that are on the video call were able to take some wonderful nuggets away from this. So that information 20 years ago, I did not have. And because that's how long I've been in the quote unquote official music business. I was in it before, but when I say business, when it got real serious, when we started looking at spreadsheets and putting formulas in them so we could see where this money is going. So that type of information would have been priceless 20 years ago. So I thank you. You saved somebody a whole lot of time running around finding it out the hard way. So let me, get right into connecting the dots, as Shekhinah asked me to do. So Jeff so eloquently talked about the technical side of what happens and getting your money after you do the album. I'm going to literally talk about the artist perspective and how all of this works. Oftentimes we think, okay, all we got to do is record it and we're good and we're to market and we're making money, and it doesn't work that way. So I'm going to cover some of those areas and piggyback off of where Jeff left off. So give me one moment.
And while you're getting that together, I want to let everyone know, just getting very transparent here. I remember when Temika came into my world, or I came into yours. I will never forget that moment. I sat right here in this office, and you gave me a play-by-play, a step-by-step of how to maximize the use of the Music Society and submitting, my repertoire, my information, so that I got my first official royalty checks because of you.
All right.
I got my royalty checks. I secured my digital bag because of you. And I'm hoping whoever is on this right now, even if you're not able to see it live, please submit your questions. Please take full advantage of this. This is being offered to you guys for free. And once COVID is over, they're going to be probably in Europe somewhere doing this for tens of thousands of dollars, and you'll probably never see them again. And I'll be right there in first class with you. I'll leave it right there.
Not business class, but first class. All right. Okay, I see how you rolling. I'll tell you rolling. Okay. Well, awesome. Well, I come from the school of hard knocks. And like I said earlier, 20 years in, at 20 plus and some change in the business. So what I'm going to share is just from on the ground experience. So as Jeff talked about, some of the PROs, also known as performance rights organizations, there are so many. First, I'd like to establish that I am a writer member and publisher member of ASCAP. So let me first break that down just a little bit. When you decide to become a member of a PRO, you have the option of becoming a writer member or a publisher member if you decide to open your own publishing company to promote your specific works. So one caveat is that you cannot be in both. A writer member cannot be a member of more than one society at any given time. However, a publisher member can. So I could be a member of ASCAP and BMI at the same time as a publisher member. And I do have a publishing company. When I started writing songs, I created a music publishing company to essentially exploit my recordings so that I would be able to license those songs for different types of opportunities. And Jeff touched on all of those, especially the sync license opportunity. Being able to see if I can license songs in film, license songs for ringtones, all of that types of things. So that became very important because I wanted to be able to handle the administration of those rights myself without giving a third party the opportunity to exploit my recordings and take a percentage and give me a portion back. So I just wanted to say that. And I'm a member of ASCAP, and I've been since the beginning. Right. Okay. One thing I'd like to note too, I'm going to speak specifically about ASCAP because I'm an ASCAP member. I have not, however, as a publisher member, joined BMI or CSAC as a publisher member for various reasons. In the early days, I didn't know it. I didn't find it out until afterwards. And quite frankly, it's enough managing one PRO and all of the administrative aspects of it. And I find that when I'm wearing so many different hats as an artist, the more that I take on, I realistically had to ask myself, what can I manage realistically? So depending on what your resources are as an artist, if you have a publishing company where you have a large staff, then I, by all means, make sure that you're a part of all the PROs. When you're a small staff like myself, me, myself, and I, and her, and she, you know, that, you know, you're divvying all these aspects of the daily work out little by little. So one thing to know, the PROs pay out royalties to writers and publishers for non-digital public performances, including the songs performed on terrestrial radio and live venues for writer members and on television. So what that means is, if I'm performing at Warm Daddy's, is Warm Daddy still around or is it a new one? I can't remember. In Philly. If I'm performing at Warm Daddy's on stage and I performed my live material, I can get paid royalties for that live performance at Warm Daddy's every time I do that show. In addition to my songs also being played on radio if I am the rights owner. not just the singer. And Jeff touched on that with featured artists versus rights owner, and I'll get into that a little bit later. And also paying royalties out for songs that are featured on television and so forth. So, and I'll get a little into that when I talk about cue sheets, because you can't get your money from songs performed on televisions without cue sheets. SoundExchange pays out royalties to owners for digital public performances. And again, Jeff touched on that, including Pandora, SiriusXM, and channels like Music Choice, which I am so thankful for, because when I look at my SoundExchange statement, that's where the majority of mine are coming from. SiriusXM and Music Choice are the majority where I'm seeing the most traction for my song. So I'm thankful tremendously. SoundExchange is wonderful. Can I say that? They pay consistently. ASCAP is great. ASCAP has been great to me. However, ASCAP pays more frequently. ASCAP pays every quarter, and ASCAP pays domestic and international royalties on a specific schedule, as opposed to SoundExchange. SoundExchange pays you religiously every month, so you don't have to wait quarterly for the distribution. You don't have to wait for international distribution versus domestic distribution. You don't have to worry about that schedule, which is great, which means you get your money more frequently. This is a snapshot of the dashboard for ASCAP. So the great thing about ASCAP is they've revamped their dashboard over the years, so it's much more user-friendly. They explain some of the topics a little bit more, because it was very confusing in the beginning when you would complete your song and you needed to register it and put it in the system, because this is where everything happens. This data entry process is where you make your money, and not because it's playing on radio. This is the moment right here. Jeff talked about these splits and who's getting what and so forth. This is a great place to make sure you get that clear, because if you can get it clear in your non-digital PRO dashboard, by the time you get to SoundExchange and inputting that data, it's real clear because you've already covered it in the non-digital PRO. As I said, it breaks down. It gives you clarification of who's considered a writer, who's considered a publisher, what your role is, and how that should be entered in the system. And as you can see in this slide, it kind of covers that a little bit, what a composer is, what an author is, what an arranger is, what a translator and adapter. Because oftentimes what I've found is in the studio, everybody thinks they're a producer and everybody thinks they're a writer in the studio. And I'm real clear. You didn't create the melody, you didn't create the lyric, you didn't come with the bridge, you don't know what instrument, you're not the writer. So if you contributed to the album, then we're talking about, then that's a conversation where we talk about, okay, let's get really clear about what your role is in this song. And I consider myself a producer, not a let me push a button and and I'm doing 4/4 beat and now I'm a producer. No. I consider myself a producer from beginning to end. From the vocal production, I know what the harmonies are. I'm recording them. I've made them. I've established them. If I'm putting strings on the track, I've laid down the keyboard string, because I don't play strings. So I've laid down the keyboard strings, and I know what sound I'm looking for. I know what the drums sound like. I know what I want the vocals to sound like. I know what I want the bridge. I know I want it breathy here. I know I want it powerful here. All of those things I'm producing. Now, by the time I get to the board and the mixer is involved, that's another aspect. That's another aspect of the recording and engineering. And Jeff talked about those people also having a part in the compensation of the song. However, all of that additionally should be discussed. And a great thing to note is if those things are already established in the beginning, I think that's a great opportunity for being able to establish a bargaining perspective, because if you're going to be getting royalties as the quote unquote producer, engineer, mixer over the life of the song in perpetuity, 72 or 70 years plus, then I probably shouldn't be paying you $100,000 for you to do a beat for me, on top of you also getting paid in perpetuity on a song. So those are some things to think about in negotiating, because at the end of the day, you know, this is a numbers game. So I'm speaking with regard to this as an indie, not a record label being funded by a private equity firm, which, you know, the majors are, you know, Sony or, you know, Atlantic, you know, all the big ones that are left. That's a different conversation. That's a different dynamic. That's a different type of business structure. I'm speaking strictly from an indie perspective when the artist is the creator and also the label and also the publisher, so to speak. Even though you separated them business entity wise, you are essentially all, an umbrella. So that's a different conversation. I wanted to make that clear because the major labels are functioning under a different model. Okay, additionally, as you can see in this slide, just further clarification about what an original publisher is, a sub-publisher. When you register your songs into a PRO, essentially you're giving them the right to be able to collect funds, royalties for your song in different territories. So that's where all of that comes into play, where who's a publisher, original publisher, sub-publisher, and the dashboard, depending on what PRO you're with, their system as well, probably just like ASCAP, breaks down each role and what's happening and who's in charge and how that split works. So I don't want to get too deep in the woods on this because that could be a whole nother presentation in itself. This particular part of the dashboard is the most important, where you're putting in the work title, which is actually the song, and you're putting in your writer shares. This screen right here that you see is everything. Because if it does not add up to the prescribed splits, and you see that on the screen, that every share must equal 50%, and that totals essentially the full share for both sides of the song. So the writer share and the publisher share. If this is not entered accurately, you won't see your money. So I'm harping on this part because it's very, very important, because this is the money dashboard right here. This is the screen. So this is very important when artists are in the studio, even before or during or at the conclusion of the song, to get this clear before you start any marketing efforts, before you start promoting the album, before you go to press, make sure this is clear. Okay. Additionally, this is breaking down the roles and what the splits are, and what role you are, so you're clear. Are you the author? Are you composer, author? Are you the arranger? Again, just being clear on what your role is. This is a snapshot of the songs that I've entered in. So you'll see there's a work title, and you'll see the date entered. You also see the work ID and the status. And this is very important. These almost become like, I don't want to say your social security number for a song, because I feel like the ISRC is like the social security number for a song. But these work IDs become very important because it's proof that you have a song registered in the system. So anytime you're referencing something with a PRO, you're looking up that ID. And should someone want to license your song, and they're coming into the ASCAP catalog or BMI or CSAC, they can see the song that's attached to your catalog, because there are different numbers. There's work IDs, there's catalog IDs. Again, those are separate classes in themselves, but those numbers become very, very important in identifying a track. So this is just a sample of all the songs that I've uploaded into the system to register so that I can begin the process to collect royalties. This slide is an example of what is called a cue sheet. I did a promo, I think it was 2014, where Centric Gospel used one of my songs for a bit, what they call a bed in their in one of their promos, and I wanted to get my royalties for that. So even for that short amount of time that the song was played in between that set from 7 a.m. to 10 a.m., I wanted to get my credit for that because I didn't know how often Centric was going to run that piece over the course of that channel. So in order for me to have gotten paid for that, even though it was played, it was not a given that I was going to get paid from that unless it got entered into the system. So cue sheets have two parts. The actual television program or the program director that's choosing a song, they need to make sure that they've submitted their cue sheets to the for PROs, and then you also need to go in and make sure you've entered the information so they can talk to each other. Normally there's a 6-month lag, at least a minimum lag of being able to get paid based on cue sheets. So I just wanted to note that if you do have an opportunity for any of the audience that's listening, if you have a song that's on television or their song is used in some type of aspect based upon the sync license where your song is synced up to a visual, just make sure you know that there's 2 steps. There's a cue sheet and and also making sure the program director of that program has submitted the cue sheet so you can get paid. Okay, next, this portion is about the section where I said if you're performing live and you want to get paid for your original songs that you perform on stage, in the ASCAP system, you actually need to upload what is called your set list. And you put those songs in and you tell them, you know, what type of venue performed at, did they sell tickets, how much were the tickets, how long was the set, how long was the song, who wrote it, yada, yada. All of that information you put into their database when you name your set list. And when you go to claim your royalties for that particular show and those songs that you use, all they do is pull from the system and show that you use those songs on that particular date. And then you get a check dispersed based on their disbursement schedule for your on-stage performances. So that part is great, especially for live musicians. So even if you're not recording and you have if you're not having your music played on radio on a regular basis, but you are performing on a regular basis and your songs are registered in your PRO system, you can get paid even though your songs are not being rotated on radio 20 times a day. So there's still an opportunity for you to also make money, even though you may not be getting the spins on radio that you would like, but you're getting spins in clubs by you performing live. So I think that's major. That's gas money, that's lunch money, that's rent money, you know, whatever. So that's the blessing. This is just a screenshot of what that data entry portion looks like. So you'll put in who the performers were, the type, the date, how long the performance was. Again, are there any tickets sold? Were there advance sales? All of that nature. Did you do any cover songs? You know, all of that gets listed in this particular section of the dashboard in ASCAP. I would suspect that BMI and CSAC have something similar, I would hope. But again, I can only speak on the ASCAP platform. So this is very user-friendly and it enters everything very easily and you get your money. This last aspect, additional areas where you can get money, royalties for what you do. ASCAP offers the ASCAP Plus Award. So if you are doing shows where you would normally not be compensated, they offer an award where they will compensate you for a certain amount of activity within the course of a particular, I want to say fiscal or business year. So as you can see here, for ASCAP to be eligible, you must be a writer who received less than $25,000 in domestic royalties in that previous calendar year. So this is money in addition that you're probably already getting from royalties or performing, but just say you could be just doing performances maybe abroad and you have such a busy schedule, but they wouldn't be on the radar of ASCAP for them to monitor those performances. So they probably, if you're, you know, for example, I know Shekhinah, you went to Cuba. They may not be monitoring, you know, Cuba and those particular venues that you went to there. So this would be a perfect opportunity to then apply for the ASCAP Plus Award, actually in two areas. Apply for the Plus Awards and put your set list in so you can get paid for the live songs that you did while you were in Cuba. So that's like a double, that's a double whammy for something that you would not have normally been compensated for generally. ASCAP or PROs survey certain types of venues. They survey a venue that they most likely have a license with. So Jeff talked about this earlier. This is very important, and ASCAP does not play. They're very serious. So just say there's the neighborhood bar. I'm going to use Warm Daddies because that's the one that's coming in my head from Philly. Most likely Warm Daddies pays a license fee to ASCAP to play music in their overhead systems. You know, like while you're sitting there eating, they're playing music, it's coming through the PA. And they pay a license for being able to have live music performed there. So those fees are the fees that get paid to the PRO, and in exchange, that money gets divvied out to the artists, either artist members. So it's very important that they survey areas where people are paying licenses. However, what I've discovered is when ASCAP finds out that you're a venue that's not paying the license fee, they come after you. They're serious about collecting on behalf of artists, which in one respect is great. But if you're my buddy that has a little juke joint over there, you're just trying to get by, it's kind of, it's kind of double-edged sword. You're like, yeah, I understand. You try to make it, but at the same time, you're robbing the artist. So it's kind of like, which side do you have pity on, right? Which side do you have pity on? So, but that's very important, because if they're not surveying a venue that you're performing in regularly, that's not licensed, here in this particular section, with the ASCAP Awards and on stage, this is a chance for you to get your money, even if your boy who's got the juke joint is not paying the license fee. Does that make sense? Because they're probably going to come get them because you put in this recording, because you put in this request. They're probably going to find them because you're trying to get money from these performances at these venues now. So I think that's another way that they try to get new licenses to see who's performing where, so they can begin to get them to pay license fees. That's just my thought process. I think that's one way that they discover who's not paying license fees for playing music. But that's just my sidebar on that. Here we arrive at the lovely SoundExchange dashboard. And Jeff showed a little bit of that earlier. This is a sample of my dashboard if I was going to enter in a new song or a new recording. One thing I'd like to note with SoundExchange, I am a SoundExchange member as both a featured artist and a rights owner. So what that means is when my songs get played on the radio, I get paid for both performing them and for having been the rights owner. So once upon a time, before the Modernization Act that passed in 2018, the artist who performed the song would never see any royalties unless they were the writer. Always comes to mind, I think, Aretha Franklin. I don't know why, when I think of this example. Because you think of her singing, R-E-S-P-E-C-T, you're like, okay, everybody knows that song, it's Aretha. So automatically people probably thought, oh my God, this song is so popular, Aretha's making money because she's singing on it. And I'm like, no, Aretha makes money if she's the writer on that song and getting paid as the writer or rights owner on that song, not just because she's famous and not just because she's the most popular person on the recording. And Jeff, you touched a little bit about that. So that's very important. That's why SoundExchange is awesome, because I feel like they open the door now for the person performing the song, the person that is reaching a person's heart, that's touching somebody's soul. They're now being able to be compensated for their performance and delivery of the song and not being penalized because they didn't write it. So SoundExchange is a blessing just for that scenario there, to say, hey, we acknowledge you and we appreciate you. And just because you didn't write it doesn't mean you're not entitled to any compensation. So this dashboard is where you would enter all of the details on your song. And the ISRC, which I touched on briefly earlier, is essentially the social security number for a song. So it's very important in the production process when you get to mastering to have already ordered your ISRC numbers, and I'll get into that shortly, for your recordings. So that way, moving forward, when you're entering your data in SoundExchange, when you're entering your data in your PRO database, like I did for ASCAP, you have the social security number attached for your song, and that song is identifiable beyond a shadow of a doubt moving forward, and it's attached to herein, forever, and now, forevermore for that song. This is a little bit more of the dashboard. It gets into very specific details on what is required. As you can see, the ISRC is prominently right there, and it's an asterisk. It's a required field. The genre, version, the artist, the song title, none of that is taken for granted. Jeff said, just because you're on the face of the cover doesn't mean necessarily you're an entitled member. So this particular data entry point of SoundExchange is important, because this is where you get to break it down. Just like he said, we don't know what to pay you unless you tell us. So this dashboard makes it clear who's getting what. The ISRC, just a little bit about that. In the beginning, when I got my ISRC, it was free. Now there is a charge for that. And the ISRC is the International Standard Recording Code. And again, I just say call it Social Security number for the song. Just make it easy. And you have to request that from the organization. And that code will then travel with each song. So the way the ISRC is set up is it breaks down the year in which the recording is done and what track that song is on a given project, and it gives you a unique identifier. That unique identifier is what will identify your particular company or you essentially as the owner of that song, essentially. So that's very important that everybody get their own ISRC, and that you keep that same ISRC naming structure as you go through your recording processes from the beginning forward, so you can keep track of literally all of your songs in your catalog, and keep them in order and monitor all that. So I definitely suggest every artist become very familiar with either numbers or Excel, depending on which platform you use, whether you're an Apple user or you're a Windows user. Become very comfortable with spreadsheets, because you're going to live in them to keep your data, your ISRCs, to kind of keep track of what's going on in your recordings. Sometimes it seems like a manual process, but keeping that data organized and roles and responsibilities, where the songs are, timing, timestamps, when they begin, when you wrote them, when you submitted them to the PROs, just like keeping track of all of the data on your songs is very important, because this is your intellectual property. This is something that no one can take from you, and it's also part of your estate. So when you pass on, and you go on to glory and you have those heirs behind you, this type of data is data that you would want to have safely secured somewhere, so that your legacy can continue on. So should someone want to license your song after you're no longer here anymore on the earth, that this data is easily accessible to those who are managing your estate. So this stuff becomes very important, because your songs are now part of your estate once you create them and make them official and put them out there on the market, and you have them registered in these systems. These are what I call forms of currency within your estate. So I say all that to say to don't take this portion of artistry lightly, because it's very, very important outside of the work that you're doing on stage. Let me say this, no encoding, no royalties, no PR submissions, no royalties, no SoundExchange registration, no royalties. So I make that very, very clear, that without these things, there are no royalties to receive. So payment of royalties is directly connected to each track successfully being registered in these systems with the correct rights owners and correct right splits. So if you are not entering the information in the PR rights management system, find out who is responsible for doing it. Just say you're signed to a small label or a larger label. Find out who in the royalties department or administration handles that, and become their friend, so that you know what's being entered and you're not taking it for granted that all of the data is being entered incorrectly, and that it is being entered incorrectly, and that it is being submitted. Also, I just mentioned earlier about encoding. I said no encoding, no royalties. So far, we've just talked about registering the songs with the PROs, be it the non-digital PROs and the digital PROs, such as SoundExchange. There's another aspect of this process that goes hand in hand with the registration of a song in the PRO databases, and that's called encoding. This is the piece that is a must if you are seeking to have your songs played on terrestrial radio. So that would be radio that is not satellite radio. So the radio you get in the car, you turn to 101.2, and okay, you're hoping to hear your song. This part is very important, because this is how those songs make it to terrestrial radio for them now to be tracked, so that you can get royalties from your PRO from those songs playing on traditional radio. So, and your songs will be encoded with companies such as MediaBase or Nielsen BDS for encoding, and I'll show you that shortly. These are the submission, These are the submission forms for encoding your music that is going to play on radio, for having it encoded with BDS, Nielsen BDS, and with MediaBase. Everything is web-based now, but I'm showing you what the online form looks like when you go to the sites. And it's very important as you fill out that information for your song, that's also very correct. And they're also too going to ask for IRCs and wanting to make sure all of the data is correct, for your particular song. As you can see, for example, over here on the MediaBase application, they're asking for the track ISRC right there. So you see how it's important to get these things in order as you prepare to launch your product. So it's kind of like each step kind of builds on each other. So having the data from the jump makes this much easier as you go through all of these platforms to enter the data. So I won't get into details on the form, but as you can see, it walks you through. It's very self-explanatory, asking you which particular, tabs to data to put in and how to submit it, who it goes to, what the format is for encoding the songs. As you'll see right here in Nielsen Music, they showed right here what the requirements are when you're sending music to them, when you're sending individual tracks. So you have to send individual tracks to them and give them each information for each individual track, and it has to come in a certain format so they can encode it, so that when it plays on terrestrial radio, that data is synchronous across the board at any station that's playing your music across the world, across the country. That's my part.
All right.
So those are all my spots: Instagram, Twitter, Facebook, Temika Moore, and Temika Moore Music on Facebook. So that kind of sums up the perspective of an artist in preparing music for market based upon the PROs and connecting the dots and making sure everything is in the correct system so that you can actually get a check on the back end. Oh, thank you so much, Jeff. So, any questions? I wanted to keep it general because some of these areas that I touched on could be another topic, could be another webinar in itself because of all of the other areas that it could go into.
Oh, we're absolutely about to get into it. I have a series of questions, some in my DM, some that's actually in the chat box. I'd like to give a hand to Temika Moore and to Jeff Bryce for such an amazing, beautiful, informative, much needed conversation. I especially appreciate the visuals. I was just, as I was thinking, I said, ooh, she broke it down. You guys broke it really down to it's like micrometer. So some of the questions, Jeff, there was one that we kind of joshed over real quick. The point about sessions and the venues and getting paid for those live performances. Could you kind of touch on that?
Yeah, it's interesting because the whole idea is that when you perform in a public venue, the venue is supposed to be licensing the use of the content. So they're licensing in a blanket license. And they're paying ASCAP, they're paying BMI, they're paying CSAC, they're also paying Global Music Rights, which is a newer organization, and there's other organizations coming onto the scene. What's interesting is that now, as you pointed out, you can actually go and claim, saying, hey, I played my own songs at this club, pay me for playing my own songs, which is really interesting. But consider this scenario where, let's say it's one of those venues that isn't paying their ASCAP fees, but you're a member of ASCAP, and you're going to go there and then play the gig, and then turn around and then sue them for infringement. It's like, what, was your music not covered by my fee? I paid you $500. You tell me I had to pay extra to use your music? I don't get it. So that's something that's a little bit baffling to me. Is the whole idea is that you go into a venue and that whole idea that you're reporting to them, the idea that it's self-reporting and not just some type of sample, is that the main advantage to them is that you're actually providing intelligence on what that venue is doing. So it's like, oh yeah, I just played music at this venue. Like, they're not licensed after all. So I'm going to have to go, they're not going to kick down doors. They have a legitimate business interest, but that's really the main advantage to them is that you're providing that intelligence. But it's kind of a peculiar situation because like, you're not really going to sue me for infringement after you played the gig, are you? Like,
I know. That's why I said it's tricky. It's tricky.
That baffles me. Like, I don't understand how that works out. Like, if you do the gigs, it's like, do you have grounds for infringement? Because it wasn't ASCAP's rights that were infringed upon. It was yours.
Right.
So it's like, okay, well, now that I played my gig, well, hey, I played a gig last night and they were paying ASCAP, so that didn't count as a direct license. I better go take this up with my attorney. Like, I'm a little bit baffled by how that works. We could go on and on about it, but that was something that always...
I thought it was essentially under the concept of assignment. So when you sign on as a member, that you're assigning essentially for the right for them to collect on your behalf. So even though they didn't technically offend ASCAP, if they're representing us, they're like, well, we're representing you. You know, you signed.
But at the time, a lot of venues aren't legit licensed. Yeah. So, we playing at Slapjack Mahoney's bar and, now they're gone after, ASCAP goes after that venue that's not registered with appropriate licensing. And now you can never play in there again because they're like, don't bring Shekhinah B back in here. She had ASCAP come after us, and now she is blackballed from this place. She can never come back. That's the end of it. And now we're in the digital space. What about performances online? That was a question. Like royalties, online, virtual concerts.
Yeah, well, those transmissions actually would have to be licensed separately. So it's not a new sound recording unless it becomes fixed. But the idea of like now it's a public transmission. Now it's going beyond the venue. That would be a separate license. So it's really a questionable space. The question is whose rights are being infringed and what are they going to do about it? Yeah. So it's like, okay, well, you're not really technically supposed to do that, but it's actually kind of cool. So I'm not going to say anything. Or you know what? Oh my God, I didn't want them to do that. They shouldn't have done that. So my rights have been infringed. And there will some that will say that.
Yeah.
So the point is artists need to be aware of the places that they're performing at so that they're actually getting the benefits, because especially if it's a place that's not paying you directly, if you're doing your music and you're performing even covers, it's important that those venues are affiliated. So that way securing the bag.
Yeah, it's either affiliated or making sure that if you are going to perform with them, that it's understood, assuming that somebody makes an issue of it, that it's understood that the fee you're getting paid for the gig is assumed to cover the use of your own compositions. It's like, all right, I need $500 for the gig, but you're gonna have to pay another $500 to play my own songs.
Even artists having that understanding of that breakdown is, a lot of us may not have the understanding to say, okay, well, how much am I charging for my royalties? What are my royalties worth at each phase? On the mechanical, like the digital markets, if I have something played on YouTube, if I have something played on television, if I'm performing live, if I'm doing something on my own Facebook, if I sing a few lines on my song, am I going to sue myself? So just knowing that.
And a live public performance is not the same as a digital transmission, even if it's live. So you might have a venue that's licensed for a live performance, but then as soon as they start transmitting to the internet, they've actually gone outside of their licenses. And if you own the publishing and the composition, okay, well, maybe, unless you're going to sue the venue, it's okay. But if you don't own the publishing rights because you wrote the song, but you sold them to a publisher, the publisher might say, hey, but now you're infringing on my rights because my job as the publisher is to monetize it, and now you've taken that away from me. Yeah. Now, the publisher might say, well, they weren't supposed to do that, but man, this is so cool because there's so many people watching it. Like, that's their right to say. Yeah. And they can decide, well, you're infringing on my rights, but I'm not going to prosecute. Or you're infringing on my rights, and it's not really the artist that's technically infringing, it's the venue. It's the venue. So the artist, that's the thing, the venue might say, artist, do I have permission? The artist's like, yeah, that's so cool, totally stream it online. The artist didn't have the rights to convey that permission. And the venue is saying, cool, we have permission. And the publisher's like, no, you didn't. And we didn't want to do that. And we have a reason. And now we had 1 million listeners. And I'm losing all my money because I can't sell the song. And now you had 1 million listeners. I'm publisher going underwater here. Why couldn't I get paid? Because I own the publishing rights. Yeah, exactly. They might yell at the artist, but it's the venue that is infringed.
Yeah.
And speaking of the publishing, there's a question about publishing. So glad that we're speaking about it just as candid as this. The publisher owns essentially a portion of the catalog of the rights of the materials that were put out. The songs, so the catalog, the publishing company, whoever that is, and it may or may not be the company. It could literally be the artist. So if you, Temika, you have your publishing company, you have wrote the song, you are the artist, you literally essentially own your own catalog.
Yes.
Wow. The question here is, Alexis said, I would like to know what would be the suggested first steps, because she's a singer, a songwriter, a producer, and an engineer developing a publishing company and to release her own music so that she can own her own publishing company, own the catalog, the rights, privileges, the soul, the blood, the sweat, the tears, all of that.
I say beware of wanting to wear too many hats. I'll say it. In the attempt to want to own and control everything, there's a downside. There's pros and cons of being the one owning everything, because that means you rise and you fall all under your name. Essentially, is she asking what does it take to be able to establish the publishing company, to be able to say, okay, I'm the engineer, the producer, the writer, the publisher, is that what she's trying to do?
Yes. Because she's a singer, songwriter, producer, engineer. I guess her first steps would be establishing, herself as a publisher for the PRO for her music.
Okay, all right. What I would suggest, and let me put out this disclaimer. Although I'm a nerd when it comes to music, I'm an attorney. I'm not an attorney. I'm a nerd because I needed to be for my stuff. So let me say that. I would personally suggest establishing an LLC and separating your entities under one umbrella. So that way you can protect yourself. Now, I've tried both ways. I've been a sole proprietor, meaning the buck stops with me, and they have the ability for me to report all my income under my social security number, so to speak. Then I've also tried it where I have the LLC and I report all my income under the company name, the limited liability company, and it's separated from my personal earnings.
Yeah.
I think it's a personal choice based upon your capacity to be able to manage the administrative responsibilities of each particular business type. And only you know that, especially where you are in your career. You might want to start out as a sole proprietor for a short moment, get your money right before you start moving in that direction. Unless you already have a really large catalog that you've already sold and you've already gotten those songs to market, then I would no, skip this sole proprietorship. I'd go right into LLC so that way you're protected. It really just depends on where you are in your capacity. Let me say that much. But I would separate all the hats. So you have your production company, if you are actually producing the songs that you're putting, and then you're calling yourself a label. Are you going to be a production company that's putting out music, or are you going to be a label that's putting out music, or are you going to be an artist that's putting out music that happens to also produce and write? Those are three different types of approaches. There's no rule that says you have to have, Mama Joe Record Company to put out an album. You can name your record company Mama Joe Publishing and put out an album. It doesn't have to be quote unquote record company. It really just depends on what your goal is and what your approach is. I always say have your own idea. And if it wasn't your idea and you can't keep it up and you can't follow it, then don't do it. And let me clarify that. You are a writer, you're a producer, you're an engineer. So I would be very clear about what your focus is, and I would establish the company around that. And then I would establish and structure my business entity based upon the majority of the activity that I'm going to be doing. That's what I would do. For the purpose of your publishing company, that could be as simple as, I'm just giving up naming names, Mama Joe, I don't know. Mama Joe Publishing Company, Mama Joe Publishing Company, and you're going to affiliate with, one of the PROs. And you can name, it could be a sole proprietorship, it can be an LLC just to get you, out the door. Just really just depends on what you want to do. So that way, when you enter your songs and you go to assign them and they ask you, okay, Mama Joe is the writer, but does Mama Joe have a publisher? Oh yeah, Mama Joe Publishing is the publisher. And then you attach those two in the system. So you can approach it that way where you just create a publishing company and it may, maybe be a sole proprietor just to get you started, but don't do that long if that's not the direction, that you're going. So that's one way to approach it. So you can actually complete the application process with the PRO.
And just to chime in, I know, Jeff, you got something on the tip of your tongue. Just to chime in, I just want to please let people know it's a little tedious to individually submit all of that information, like your cue sheets, your repertoire, the songs. And then we didn't really speak about this, but having the songs copywritten so that it's effectively accepted into the PROs. That's fine. That's what I'm here for. That's what I'm here for.
You know why I didn't touch on that?
Bring it in, sister, bring it in.
Because it's kind of two thoughts on that.
Can we dispel the narrative of the poor man's copyright? Because it doesn't exist.
Yeah, entertainment attorneys will dispel it for you. Don't cut it out real quick. So don't even do that. Send it to yourself to the mail and come back. No. Once you record, but let's be real clear though.
Okay.
Once that song reaches a fixed recordable medium, an MP3, a CD, a vinyl album, a cassette tape, an 8-track, whatever, once it reaches that fixed medium, it's yours. It's done. It's a done deal. That intellectual property is there. However, the purpose of the quote unquote copyright with the U.S. Copyright Office is in the case that you need to pursue litigation. In the case that you have to go through some type of legal administration of the song, or somebody's claiming right to it, that's when that comes into play. And then you can prove whoever's the first to register it is the one that has the priority. So if you go ahead in your production process to copyright your songs, and you go ahead and copyright it, and you're the first to do it, and you have it, you get your certificate, and you put all that in with the U.S. Copyright Office, you have a legal leg to stand on should you need to go to court. Should you need to go to court. Now, I'm going to say this. When you are first starting out in this business, yes, you can spend a small fortune, hire an attorney, submit your copyright forms because you're intimidated by it, you don't want to do it, let them do it. You will waste your money because you're trying to follow all of the rules that everybody tells you, but these are the rules that the big boys are playing by. So they're giving you the rules based on the big boys because they need to protect their entities. It costs at least $1 million to break an artist. Yeah, we registered the song with the Copyright Office. But if you're an indie artist, you put out an album, you spent like $5,000 to put out the album, you're doing your best, you barely got money to even hire a radio promoter to even get the song on radio in one of the 19 spots, which is a whole nother topic. You barely got that money, but yet, we're bringing in attorneys. We paying $35 for the copyright, the cheap copyright, because there's a much broader copyright.
Yes.
$35 is the cheap one. That's the SR. That's a whole nother topic. There's different, each song has an inherent rights, and you have a sound recording, you have the lyrics, totally different topic. I say if you're just starting out, be realistic about your money. Now, I'm not saying don't be wise when it comes to the way in which you're approaching your career legally. What I'm saying is pace yourself, because you will be spending a small fortune just to keep up with the big boys in these processes. So if you copyright your songs, even if you do the cheap route, the $35 one, it may be more now because my last recording was 2016. So in going through that process, you might pay for the cheap, process and copyright the sound recording, assuming you're not with the record label, because if you were with the record label, they own the sound recording. If they paid for the album to get recorded, that's another topic.
On top of topics.
On top of topics. So, you could do that and it's out the way, but just know once you recorded it in fixed medium, it's yours. Unless somebody's coming after you and they're claiming something in that song belongs to them, you probably won't be in court unless you foresee, but nobody can ever foresee, legal disputes. So that's what I'm saying. I'm not an attorney, but I'm giving you all the different ways to approach it, but also pace yourself financially in this process, because you can spend a small fortune trying to cover all of these areas, and sometimes you're not even there. You're not even at that point just yet. Not that you won't. You're just not there just yet.
Oh, that's right.
Does that make sense? Oh, that's not bad advice. I'm just giving the full.
But this is before I'm bringing you back in, Jeff. I'm bringing you back in. But this is why it's important for everybody to structure their entity contingent upon their financial plan, the activity that they're actually doing with the entity, whether or not they need to have an entity in the first place, and whether or not you have the efficacy to fully manage it and then follow up each time you're performing. Because if you don't have a team around you, it is literally all on you. So artists, a lot of times when you're considered for a possibility for being at a venue, they're looking at, well, what's your promotion look like? What's your social media like? What's your marketing? Are you ready with your press kit? Are you available? And do you have everything that's necessary? And are you going to submit the things? Like, you have to follow up with all of those steps. You literally, I remember we talked about this before. You said, I have to wear this hat today, Shekhinah, so I'm not going to be available. Shekhinah, I got to wear the marketing hat. I got to got to upload my cue sheets. Wait, quick question. Can you break down a cue sheet?
Is that me or Jeff?
Either one.
Oh, Jeff, did you want to chime in?
Yes.
Chime in.
Yes or no question? Yes, I can. But I also wanted to piggyback on what Temika said. I'm not an attorney, but I am also a nerd. So I appreciate that about you, Temika. I appreciate the nerdiness. That's my favorite. I wanted to touch briefly on the copyright registration process. Really, when it comes to copyright protection, it's a matter of evidence in court. Like, what evidence can you provide that you own the copyright? Now, when it comes to copyright infringement, like somebody stole my song, that's where, like, can you prove that you wrote it first? Or that can you prove that that was your original idea? That's where the poor man's copyright comes into play. It simply provides evidence. But it's not the same as a copyright registration with the Copyright Office, which entitles you to statutory damages, which is an important distinction. If you're not registered with the Copyright Office, but you have fixed your content, you have published it or whatever, you can still protect it, but statutory damages come into play when you register it with the Copyright Office officially, because in terms of evidence, that's the best evidence that you can have, is registration with the Copyright Office. Now, with respect to a business owner who is great at everything, are you really great at everything? I'm mentioning like wearing many hats. I mean, that's a lot of different specializations. But if you're new to the business, but you happen to have these talents and you're good at these things, you know, that's whole single member LLC is a great place to start. And really, I mean, what's the point of forming an LLC? For tax purposes, it is indistinguishable between yourself as an individual or your business. For tax purposes, it's what they call it. It's like a fiscally transparent entity or something like that. There's no distinction between your income and your LLC's income. But think about the term LLC, that is limited liability company. What does that mean, limited liability? Well, that protects you and your personal assets if something goes wrong. For instance, I formed my LLC after I was playing music for a while. Now I've been playing professionally. Now I'm doing gigs under my own bands. Now I own my own PA. Now I've got all this stuff. Now I'm owning all these things. And then my speaker nearly falls off the stand and hits somebody on the head. Well, I sure would like to limit my liability so they don't come after my house because they got a boo-boo. You know, so it's like, okay, well, I established the LLC to protect myself from liability, so I separate my personal assets from my business assets, and the LLC is the starting point of a business that's growing into something else. So if you're really planning on growing into something else, well, the LLC is a great place to start. And what you really want to do as a business owner, no matter what business you're in, it is perfectly acceptable to combine all of your publishing and your sound recording, all that into one place, especially at the beginning, because there are effectively not that many different lines of businesses for you. But what you want to do is establish your business as a separate entity so it can be respected as a separate entity when time comes for that to be so, as a taxable entity later, but also protect your personal assets. So you really, when you run your business as an LLC, you're really in the process of separating yourself, the person, from a business. It's not distinguishable yet for tax purposes, but you're on the track to build into something else, maybe a larger corporate entity. But you start out by forming your LLC, and then you start to create separate accounts and separate assets and start talking about your LLC as something separate so that your community recognizes you as something separate, that the media recognizes you as something separate. And then eventually you can, as you grow and you start taking on additional artists or start building out your content and licensing in different ways, now you start growing into different things. Now we need to hire people. Well, now you start getting into a corporate entity. Now you've built up some credit as a separate entity. Now you can launch into an actual corporation, which might be a necessary step. That's really the main advantage of the LLC, is it's an intermediate step onto something else. It's not useful for tax purposes at this stage in your career, but it might be useful for starting off a business that grows into something else for the purpose of creating a separate entity that can be respected as a separate entity. So that's really what it comes down to, is are you good at all of those things? And whether or not, fine, roll them into an LLC, but run your LLC like it's separate from you.
Right.
Treat it like a separate person. The Supreme Court has ruled that corporations are separate people. Treat your corporation like it's not you, because if your customers can't differentiate between you and your LLC, then they can sue you and get your house anyway. They can pierce the corporate veil, as they say, and go after you personally if you do not treat your LLC like a separate entity. They can still do that. They can still do that with corporations, pierce the corporate veil. But it depends on how you do your business. So you run your LLC like it's a separate entity. Keep a separate book, a separate account, write separate checks, talk about it separately, advertise it separately, that it furnishes your services, but it's not you. That's the way you protect your personal assets, and it's still a risk, but that's you building into something else. The LLC is not like an endpoint as far as I'm concerned as a business consultant. It's an intermediate step to something bigger.
Right. I'm so glad that you made those distinctions, and that was very comprehensive and laid out straight. One of the reasons why I encourage all of the artists, I'm putting in a plug, the Art Economic Empowerment Workshop Series, where we break down the differences of business structures and the importance of what you said, separating individuals from said corporate entity. So if you're going to have a business and you're making business expenses, don't use your personal checking account. It should all be coming from the corporate account, the corporate credit. You should be filing your corporate taxes separate from your 1040s, but that's a whole other conversation. So when we start up the Art Economic Empowerment Workshop Series for emerging artists and emerging artpreneurs, we're definitely going to dive into that. I might have to bring you guys back in again on something. On
Schedule E, the Schedule E comes in on that. The Schedule E is for royalties.
Right.
So that comes into play, when you are filing your taxes. So one thing I'd like to say about it, again, seek legal counsel. Everybody's scenario is different. I've been on every gamut of it. From the jump, have an attorney come in. I've also consulted with entertainment attorneys for various aspects. And it really just depends on what your vision is for your brand. Protect yourself legally, but you sometimes we can put the cart, before the, you did one song, one track, and you're like, okay, I need to hire, Robert Shapiro to be my attorney, because, I'm just saying, pace yourself, because it's a different game when you're at the majors versus indie. And if you're an indie doing music without a company, just putting out music versus an indie with an established entity versus being an artist with a corporation, those are all different environments. So I think it's important to kind of figure out where you are, where you're going, and approach your career, the business aspect of your career, with wisdom, because there's plenty of people out here wanting to take your money.
Yes. Oh, back to somebody sent it again. Cue sheets. What are cue sheets?
Well, that's just literally what the transmitters or the users of your music are obligated to report to the publishing administrators, ASCAP, BMI, and CSAC.
Okay.
What did we play?
All right. And I think you answered this already, but you can say it again. Is SoundExchange free?
Yes.
Okay, there it is. Are there any other questions before we? Are there any other questions? I see my DM is popping with things that kind of was answered already. Oh, wait. Okay. Yeah, I have two different things going on. Okay, the list of PRO licensed venue. Is there a list of all the venues that are accessible to for PRO members to get their royalties and credits?
I'm not aware of a comprehensive list now.
You probably have to ask your PRO maybe to see if they have a list.
Yeah, it's more like you check the venue and then they advertise that they are, or they'll make a point of it just to be clear.
Yeah, they'll have the stickers.
There isn't
stickers on their door. Yeah, like if they're BMI or ASCAP or CSAC, they'll have stickers normally on their door to let you know that they are every time I've done a venue and I see those stickers, I smile. I'm like, okay, I know I'm getting paid.
You know what? I do know of one venue. I'm not going to say that venue's name, maybe, but that particular venue, I've never seen it on their door, but I know they are legitimately.
Yeah. Well, I like to see the stickers because it lets me know they understand that they've been touched by the process.
It's beneficial.
Yeah. Think about that from the artist perspective. Like you're trying to book a gig, and it's just like, wow, I have an offer to play at this club, but are your licenses in order? Well, I'm waiting. It's like, no, I'm going to play the gig. Absolutely.
Okay, let's talk about this. This is a good question. Cover songs, submitting for cover songs, because that's a lot of artists are creative performers, but they may not be creative literary artists, producers, engineers.
My take on this, and everybody has a different take. I'm literally an oddball on this. I am not a fan of covers.
Okay.
Not that I don't love songs that are written by other artists. What I say, I'm not a fan of cover songs. I'm not a fan of cover songs in my business model.
Okay.
And I'm saying that because I'm wearing a lot of hats, and that means I have to manage that in perpetuity. And I don't have the capacity to do it. Been there, done that, got the t-shirt, the mouse pad, and the Frisbee. So that means if I do, I'm just going to throw out one right now. If I do Whitney Houston's cover, I Will Always Love You, which was not hers, it was Dolly Parton's who wrote the song, Whitney performed it. That means if I want to perform that song, record it, that means I have to pay the rights owner for the mechanical royalties, number one, to press it up and sell it, stream it, whatever, to the public. That's one aspect. And I need to pay them for every copy that gets sold. Mm-hmm. How on earth, as an indie, am I going to manage that for the lifetime that I'm here on earth, and then pass that on to my estate for them to manage, of keeping the administrative details of that cover paid for, because you essentially create a bill when you do a cover song. I'm sorry, you just do. So I'm not a fan of doing them, because it creates another bill for me now to have to manage, and it ain't my song. But I'm getting to develop currency, what I consider marquee currency off of it, because if I do very well with that cover, I can use that as a calling card. So now I'm famous for doing that cover, but that's all I have is me being famous for it. I can apply to SoundExchange for being a featured performer on that song, singing it, but that's it. But I have a bill forever because I recorded that song and I'm selling that song.
Not too much. Oh, sorry to interrupt.
No, it's cool.
Not for. That's a good question. That's a great question. No, I said that's a great question, because I do know of several artists that have recorded works that were already made and were already done, and they'll say, "Well, I'm going through the new distribution system, such as like a DistroKid or a CD Baby, and now they've purchased." What is the process in terms of you live performing? Because we have wedding bands, cover bands, hustle bands, and everyone's singing. The majority of the music is not their original music. They're doing covers. Yeah. What is the process to submit for even the artists whose music you're covering?
Well, you're covered when the public performance of it, you're covered. You submit your set list to ASCAP, for example, say, hey, I performed, I Will Always Love You in my set, and it kind of goes from there. That's not necessarily a bill on you per se.
Right.
For that, because the venue is already paying a license fee to perform music in that venue. So they're paying for you to do that cover. Most of the time they want you to do covers. They don't want you to do your originals, but they don't get people drinking and buying food off of songs they don't know, because those songs are not playing on the radio to get people in the door. That's why cover bands do so well, because they get to sell more drinks and food, because that's the business they're in. They're not in the music business. They only buy a license because they need to sell food.
That's right.
So if we're clear on that, that's I think depending on what your goal is and what your focus, I figured out a long time ago, I'm nobody's entertainer, and I don't do cover songs like that because I don't want to pay the bill. I discovered that I found more joy in writing my own material, even if it was not getting the volume of traction that a cover band would get. But for me, for a long-term gain, writing was better for me because I'm still eating. I'm eating off any cover song, a cover song that I would have recorded. The cover songs that I did record, I took them out of print so that it wouldn't sell, because I don't want that bill. Because I don't want that bill in purpose. It's just too much. And for the songs that I chose, if I wasn't going to go through a major marketing and promotion campaign, like, for example, Layla Hathaway's Angel, when she redid Anita Baker, unless there's a major push and there's money to put behind the cover, I don't see the economic value for me to do a cover. And I'm not going to spend 20, 30, 40, 50 grand for a radio promoter to promote the cover song just so I can get more notoriety on the radio. And then hopefully I can use that as exchange to get more gigs and venues, because that's not necessarily always the winning formula either. That's not always it. Even though it is a formula for some artists, and it's worked very well for Layla. She's like the king of the queen of redoing covers and making them her own. That's just not my sweet spot. When I do a cover song, it's because it's a particular reason and I'm doing it at a particular time, but it's going to take a lot for me to want to record it and make it another bill.
And what you're doing is setting the tone for the long-term implications that you have no ownership. And at the end, you are just an instrument.
Yeah.
Nothing more, nothing less. Yeah. So.
But everybody has a different perspective on. Some people are like, no, that's really a one-sided thought. That's kind of selfish to not want to do covers. And I'm like, no. I didn't say I love
personal business philosophy.
Yes. I don't want to spend that. I don't.
But at the same time, there are performers, artists, entertainers that may not have the creative acumen that you have to build and manifest creative literary works. Therefore, their way in the door is I can get paid to perform said song. So that's their goal. That's their hustle. It's kind of like, okay, I can go on this tour. I can perform this song. Unfortunately, it's like 6 in one hand, half a dozen in the other. So it's not one is any better than the other. It's just a perspective, and people should know that. And that's good that you said that.
Yeah, the question about the cover, I was actually a little unclear. When it comes to performing covers, if it's a live performance, then it's the venue that's responsible for paying that licensing fee. And if they're paying their licensing fees like they're supposed to, and again, that's the whole concept of the blanket license. This is a different blanket license than the one I discussed, but it's the same idea. That if a venue is paying their ASCAP, BMI, CSAC, GMR, and all their licensing fees, then the bands that play in that venue can play whatever covers they want. Largely speaking, broadly speaking, in a blanket, they can play whatever they want. It's when you start getting into the recordings of covers, when you start getting into reproductions, that's where you start getting into those issues where, like the Whitney Houston covering Dolly Parton, that's a great example.
Right.
Where if I want to ask Dolly Parton permission, or really not Dolly, but her publishing company, I don't know if she owns the publishing or not, if I could ask her, and they say, man, I love you, Temika, I would love for you to cover that, no charge. Great, there you go. That's a direct license. You're welcome to it. But if her publishing company just can't be found or says, man, I don't want you to cover that song, I don't like you, Temika, like, I'm going to record it anyway under the compulsory license.
Yes.
I'm going to pay you 9.1 cents for every reproduction of that song, and I'm going to do 1,000 CD pressing through DistroKid. What's it going to cost you? $100, $91 to press that cover? But man, you just slayed that version of that song, right? Mm-hmm. But so you paid less than $100 for you doing this great version of this song. You did such a great version, and man, that's getting played on Sirius now. Well, Sirius is going to pay Dolly Parton's publishing company for the use of that song, and then they're going to pay SoundExchange for the use of the sound recording. Dolly gets paid when that song gets played, but then Temika gets paid when it gets played on Sirius through SoundExchange. So everybody gets paid.
Yes.
So there's that advantage to that. And some genres lend themselves to covers. For instance, I'm a saxophonist, so the music I play hews towards jazz. You have to play covers to be considered credible as a jazz artist. Mm-hmm. So I have to record covers, the songs that I didn't write, because people need to hear. I need to hear how he does that song, because that's what sets you up as a credible jazz artist. So it's essential for me as I advance my career to record covers and put that information out there so that I can be considered credible. And then again, the same licensing structure comes into play. And then, wow, I've got this great jazz artist that he just really knows how to play these, like he just plays all the classics really great. Now people are going to my gigs. They're buying my recordings, they're streaming me, but most importantly is their promotional value. They're coming to my gigs. But now you're listening to it 101.2. Well, they're paying Dolly Parton through ASCAP, BMI, and CSAC, but hey, you got free promotional value. Maybe more people will come to your gig. And so maybe they're coming to see you at the Trocadero. Maybe it's free promotional value. Right? So that's how it is. Hashtag show biz, as I like to say.
Yeah, exactly. That sounds like free promotional value.
Exactly.
Nothing's ever free in this business.
Yeah.
Let's talk about the songs that are, I guess, now public domain. They've existed for as long as they've existed. I think it was 70 years, 75 years, and now it's public. Yeah. I know there are several individuals that have gone back into the wadis of the past and said, hey, this song is up for public domain. I want to put it out so I can give visibility for me as a brand. What are your thoughts?
Well, I mean, public domain you're talking about some really old classic content, so it goes back, and it really, this is what's interesting is that it varies by country. There's different statutes, and it actually has changed over time. I believe for the underlying composition, it's like life plus 75. So you're talking about music that's, potentially more than 100 years old. Mm-hmm. Sound recordings are probably not going to be in the public domain in the United States. There are recordings in the public domain in other countries, and this is where it gets complicated, that like a Beatles recording might be in the public domain in the UK, but not in the US. but the underlying composition might have to be older. So it really varies by country. But the idea is that if you're doing like a traditional song like "Swing Low, Sweet Chariot," if you're doing like your version of it, or just your version, then the sound recording becomes protectable, but the composition is not. No, it's a traditional. Nobody owns the rights to that. It belongs to everyone now because it's been out for so long. What's hard to understand is like, is this song actually in the public domain or not? It's not public domain because it's old. It's by like a specific period. So, for instance, "Happy Birthday" isn't a public domain song, but people sing it all over the place. It's not really a public domain. So
this is Stevie Wonder's version.
Yeah. So, then that's an important point, because then you have different versions. You have different arrangements, which become like those can be distinctly copyrighted. So so it's like, is it really public domain or not? You have to be careful about that. But whether or not it's public domain, the sound recording itself is not public domain. So I could record Mozart. Okay, Mozart's public domain, but the recording I just made is not. So I might not have to license the Mozart composition, but I will have to license the Mozart recording, because it's distinctly exploitable. That's the key point that I tried to make earlier, is that it's distinctly exploitable.
Yeah. Can I piggyback off of that? Because that sound recording portion is like so major, and I learned that the hard way. So I'm gonna share this. When you're the label, you're spending the money on getting that song in a fixed recorded medium. So you're the one putting it out. So you own the widget, so to speak. The widget contained on the disc or the tape or the 8-track. You own that. Now, the record label doesn't necessarily own, like you said, the content, the composition, but they own what you are sonically hearing in your headphones. So that's kind of like, it seems like it gets a little tricky, because they're like, wait a minute, I can do whatever I want with this song. You don't own it. So it's like almost like there's a separation, like a parting of the sea, you know. So imagine that it's like, okay, the song and, you know, the parting of the sea, the sound and the underlying composition. So hopefully, as a DIY artist, I mean, we endeavor to not part the sea. We want it all. But when you have all of these other parties involved, it gets a little tricky. So let me give a little transparency. I did a remake on a song. And I wrote the song, I own the song, wherever I take it, forever, here and evermore is mine, in my best English. However, I wanted to try something. I wanted to experience what it felt like to put out a product on a label where I didn't have to do all the running around and do it. So that meant I gave up a certain degree of rights. I will never do that again. And I'm saying that because I started my career having rights. So once you start your career having rights and somehow you give a portion of it away for perceived gain or to get an audience or whatever, you have to be okay with the downsides of that, which means you no longer control the right to manipulate that sound recording, not the song, but the recording. So if you want to press up CDs, you know, vinyl, whatever, you got to go get permission. I hated that. Can I say it? Say it. I was so accustomed to being able, I put it out, press it when I want to, how I want to do it. I had to go ask permission. Can I print up X amount of CDs? That irked my soul. It irks my soul to this day that even giving away that portion of right, even though the song is popular and it's well received, I hate that I had to ask permission to press something when I never had to do that. Does that make, I can't tell you how angry I am about just even trying that, because it tied my hands. Just that small giveaway on one song. So I'm telling you an experience on one song. We haven't even reached an album. One song. And I'm saying that to artists because I really want you to understand the impact of this. It's one thing to want to be able to build that marquee value and exchange that as currency, because essentially that's what you're doing. When you're trying to get on radio, you're trying to get promoted, you're trying to be the name that's in the top of mind, you're essentially paying for fame, so that you can then use it as a form of exchange, as a medium of exchange. So if you're willing to put the dollars and the cents and the blood and the sweat and tears into building fame so that you can then use that as a medium of exchange, then that means you're okay with everything that comes along with it. Meaning you give up your rights, you give up your ability to make choices with regard to how you're going to manipulate a recording, because you would no longer have the right to exploit a recording because you don't own it. So if you're okay with giving up ownership in any capacity of your career, and I'm not a control freak, I'm saying this from the standpoint of how I started. So if you're starting your career in complete ownership and you switch along the way for fame, just know you're not going to have that same degree of ownership, not to the same degree. Mm-hmm. And I would just say, just think through it and ask yourself, are you okay with that? And by doing that, you're also putting your income in somebody else's hands for perpetuity. Because if you don't own the sound recording, when you're no longer here anymore, who's going to hold that company to paying you your money? Because they're owning it, manipulating and exploiting it, and you're no longer here anymore.
Ooh, you better
hire an attorney. So now you can go after them. So now you can have access to it. I'm just like, it's just too much. This is why the big boys have the resources that they have behind them, because this game is big. Like I said, if it costs at least $1 million to break a new artist, if I'm putting that amount of money into an artist, you best believe I'm covering all areas. I want publishing. I want everything attached to your image. I'm getting all my money because I know how much it costs me to put you out. I understand why labels do what they do. I get it. I understand why they do.
I'm so glad you said that, because a lot of artists don't realize that even when they fail, they're technically a tax write-off for the big guys.
Absolutely. And
they're still going to get money, which is why artists will put out album after album when they give away that creative control, that, yes, you know, that entire control for their being exploited. They're not making money off of any of this for a long time, if ever, which is why you see so many artists with the struggling artist narrative. Where does it come from? That idea, that pathology. So we're hoping that this conversation with everybody, as we're wrapping up, we're hoping that this conversation allows many of you guys to think about your choices and understand that you do have access to systems to support you, and you can cut out the middleman and be successful. So if you're thinking long-term legacy building, creating something to pass down, leaving your mark in a way that makes sense for what you represent, this is information you definitely want to please review this video, send your questions, and any last remarks? Jeff, Temika?
I'm sorry, go ahead, Jeff. There was one, I just wanted to piggyback off of that licensing thing. It was one other.
I don't have any last remarks. Please go on, Temika.
Go ahead. In talking about sync licensing and wanting to license your song for movie or film, there's one aspect that I want to share with artists as well. It is wonderful to get your song synced to a visual. However, what most people don't tell you is you give up a lot. So, for example, I had an opportunity to get asked that I want to submit a song for one of the major networks. And I saw the contract and I saw what it was going to be for the song they wanted to use. They wanted to use it for 3 years, pay me for 3 years for the use of the song, and it would be a lump sum at the front. But then they would have the ability to exploit the song in perpetuity in perpetuities forever.
Forever.
They would only pay me for 3 years.
Right.
And that was their customary language in their setup as music licensing, as music directors and so forth for films and searching for film music supervisors and you know, that whole gamut. And I was like, well, every music licensing contract that I've seen, I don't like. So somebody might say, well, wait a minute, your song, that song that they wanted to use was it's been sitting there for 3 years. You're not using it.
But it's yours. But it's yours.
But it's yours. Like, they were like, well, the song's not doing anything right now. So why wouldn't you just take the 3 year lump sum and, you know, keep it moving? Because after 3 years rolls around, they're spending my money.
And the 4th year, and what if you spent all of that money? Now you still need money. And
they're using my song in perpetuity, and you only paid me for 3 years. Something's wrong with that. So for me, I've turned down those opportunities. Somebody say that's stupid. I turned it down because I know what it's like to give up my rights for one song. Do you understand what I'm saying?
Yeah.
Better yet, I know what it's like to give up my song for not having to do with television. But if I didn't like that experience on just licensing it for mechanical and production, so to speak, there's no way I'm going to enjoy it on the television perspective when it's 5 years down the line and they're playing my song and I don't see a check. I already know this. So I'm saying all that to say, yes, fame is wonderful because you can use it as a form of exchange, but just know there's pros and cons to it. And I think you have to name your price in the beginning and what you're going to give away and what you're willing to hold on to and what your end game is, what your goal is. So I established a while ago that I'm not trying to become anything in the music business. I already became it.
I'm about to say you are somebody.
So I'm not trying to become something. So I don't feel green and eager about giving away my rights to anything. Right. So I learned a valuable lesson on that one song. So I'm like, if somebody wants to license my song, they're going to license it directly with me, not through a third party. It is going to be on my terms, not through a blanket contract that's given to standard folks when they're doing films. Well, this is the standard when we do films. This is how music supervisors source songs. Source it somewhere else. I just won't be in it. It's not worth it to me because of my experience. Somebody might say that's not wise. Use it as a loss leader. Use that to generate income in another area. That is one way to look at it. But when you've experienced what I've experienced, I know what it's like to feel the sting once you give it away. So I wanted to give that's the other side of the coin of having those experiences where you can get a song license and it's wonderful, but what happens after that initial licensing period is done.
And one of the reasons why Michaela from Chewing Gum decided not to give up her rights for the contractual agreement that the streaming company wanted to offer her, and she decided to go elsewhere because she completely started a whole new team as a result of just a deal gone bad. And sometimes artists are in such dire circumstances that it may seem like, oh, well, here's $25,000. And they're like, oh my God, $25,000. And they don't realize that's the last time you'll ever see money for any of that ever again. And whatever you can't even use it, you now have to pay them for it because it's no longer yours. You just sold it. That was one of the, crazy things from I love these biopics that come out and they kind of josh over it. Like when Twinkie gave up her catalog, yes! And I'm just like, somebody wanted one of the songs from my catalog, and I said no, and they said, well, it'd be better to get something than nothing. I said, well, this is worth more than whatever. I'm not driven by the money. I'm driven by the legacy of it, what it represents, what it reflects. So I completely understand, and it's no shade to any artists that have gone through that, because I know a few artists that in the network that have gone through that experience, and they went through the streaming services and they sold and they got a lump sum, and it was like, yeah, I'm living off the hog. And then you see a GoFundMe later. Like, did I throw that out there? You know what? That's all I have for tonight.
You did.
We will have to absolutely do more of this. I appreciate you guys. Tamika, Jeff, thank you so much for sharing your expertise, sharing your experiences. We're going to do this again because 2020 is so pivotal, even though I'm trying not to use the P word anymore, in the changes of how artists really need to reframe their mindset on pursuing their endeavors, making it profitable, making it, worthwhile long term as, this enterprise of what we're doing. Yeah. So thank you.
And you picked the perfect person. Jeff he's a beast.
Both of you are perfect people.
That exchange backwards and forwards. So you're awesome. You're awesome.
You're awesome.
You're a wealth of knowledge. You are a blessing to the music community. I'm so glad we connected. And we connected when I was doing one of my seminars. So I'm glad you came because you're the gift that keeps producing. You keep giving.
Well, thank you for having me.
Yeah, we definitely have to do this again. So everybody that's in the comment section, if you came a little late, it's okay. This will be recorded. It's already being recorded. It's available on all the pages, the Women's Coalition's page, Shekhinah B page, my personal page. You can share it to as many people, as many artists. Everybody needs to see this. Everybody needs to understand the importance of understanding how to secure that digital bag, getting your royalties and all of the sorts. And with that, take care of yourself. Bye, guys.
Thank you so much. Hi to everybody out there, and wish you the best of luck as you begin your journey or continue your journey in music.